So thank you so much for inviting me to be part of this conversation. I've been in conversation with the CNJ for a number of years, and it's been incredibly enriching. I'm very impressed by the organization, by the care that you take to assess new policies, and your openness to global learning and trying to make the Brazilian justice system operate more fairly. So as you heard, I'm legal director for the Americas unit of Fair Trials International. Fair Trials International, we're based in London and Brussels, and we work for the protection of human rights through the protection of criminal procedural rights. And we work comparatively by bringing experiences from global jurisdictions to inform domestic criminal legal reform movements. And today I'm going to speak to you a little bit about negotiated justice. It goes by a number of different terms: plea bargaining, non-prosecution agreements. There's other forms of negotiated justice that exist around the world, and Fair Trials has been involved in studying many of them. And I'm going to speak with you a little bit about my understanding of the ANPP, this new negotiated justice instrument in Brazil, and how we might think about its operation by reflecting on similar functions in justice systems around the world. So Fair Trials has been working on the issue of the growth of plea bargaining around the world for about 5 years now. In 2017, we published a study called The Disappearing Trial. And for this study, we surveyed over 99 legal systems, 99 countries, and found some form of plea bargaining, some form of negotiated justice in 66 of them. And we know that since that time, more countries have introduced forms of negotiated justice. In fact, we found a 300% rise in the use of negotiated justice globally in the past 3 decades. Just to speak of definitions a little bit, we define what we call trial waivers. That's how we categorize this form of justice, a waiver of the right to trial. Our definition is a procedure regulated by law in which an accused person agrees to waive their right to trial in exchange for some benefit by the state. And these forms of adjudication can be really important mechanisms for exercising appropriate and proportional leniency, for shortening or avoiding pretrial detention and incarceration, and for creating individualized responses to harms committed by accused people. And I understand that these noble objectives and impulses of restorative justice are a big part of what's animating the implementation of the ANPP in Brazil. And so I congratulate all of you on thinking about how to make the system less harmful through the use of negotiated justice. But for Fair Trials, for an organization that focuses on the importance of criminal procedural rights as human rights, plea bargaining, negotiated justice presents a fundamental challenge. Because, I apologize, I'm joining you by phone and people are calling me, presents a fundamental challenge because it avoids all of these procedural protections that go along with trials. It removes the burden of proof from the government and removes judicial oversight over the legality of the actions of police and prosecutors, and reduces transparency for the public. And these can all present pretty serious challenges to the administration of justice and the rule of law if they're not carefully undertaken. We identified in our study of plea bargaining systems, trial waiver systems, very much these problems with judicial oversight. We found a reduction in the identification of torture in systems that used plea bargaining. We found evidence of high rates of people who are innocent pleading guilty in negotiated justice systems, and impacts on the rule of law and the relationship between the powers of the judiciary and the powers of the prosecution that weren't always fully understood when negotiated justice was undertaken, and aren't always visible in the very first years of implementing these forms of justice, but become clear years and decades on. We've also found that with this lack of oversight, with the lack of judicial review that comes with trial, there's a failure to provide feedback to the police about the legality of their actions. So the police are still incentivized to use arrest and prosecution and to use the justice system as a means of extracting wealth from poor people. The basis of the lack of judicial oversight and the shift of power from the judiciary to prosecutors is the basis on which, for example, the Portuguese Constitutional Court has found negotiated justice, plea bargaining, to be unconstitutional. So not every country has found it compatible with their constitutional order. It does have the effect of empowering prosecutors who can craft these offers, who have exclusive access to the evidence, and leaves a more limited oversight role for the judiciary. And what's worse, we see that although guilty pleas may in some individual cases create more liberty, more proportionality, in individual cases, on a system-wide level, it can do quite the opposite. In the USA, for example, where approximately 98% of cases are resolved, adjudicated via guilty plea without a trial, plea bargaining has been an essential facilitator of mass incarceration by allowing the criminal justice system to expand massively in volume, allowing us to quickly process, that is, impose convictions on millions of people in a way that we would not have been able to if we had to give everyone a trial. So plea bargaining can have what we call a net widening effect. And in the US, this has meant that with the ease of pushing cases through the criminal legal system, we have increasingly turned to criminal prosecution as a means of dealing with social problems that would be better dealt with in ways that don't involve criminalization at all, like poverty, inequality, homelessness, drug dependency, and some forms of intrafamiliar and communal violence. The answer to all of these complex problems becomes prosecution, because it's simply so easy to prosecute people and convict them. And over time, the effect can become even more insidious, because what happened in the USA is that over time, prosecutors started to go to legislatures and demand higher and higher sentences and mandatory minimums for the use of threatening people with very high sentences so that they would plead guilty. So it feeds lengthy sentences on a policy level, as well as widening the net of what we bring into the criminal justice system. So just to give you an example, a prosecutor can say, for example, well, you're facing 20 years if you're convicted at trial, but if you plead guilty today, you can get only 5 years. This is not exactly how the AMPP works. I'm just showing you how the power dynamics can operate in negotiated justice by placing so much power in the hands of the prosecutor. So the system-wide effect of widespread plea bargaining has paradoxically been to increase incarceration, both pretrial detention and sentence length. And I have a little video that I wanted to show you that's subtitled in Portuguese that explains how this works. I don't know if we're able to show it. Can anyone there in administration tell me if they're able to show it?
Sim, yes.
Okay, great. This would be a good time for it. Or I can keep talking and you can show it. Okay, good.
The United States has one of the highest rates of incarceration in the world. This means that we have one of the highest numbers of people incarcerated currently, the highest proportion of our population in prison, and we also have the highest proportion of people who are under court surveillance of anywhere in the world. This is not a reflection of who our people are. It's a reflection of political choices that we've made. And plea bargaining is a huge piece of the puzzle as to how we got here.
Mass incarceration feeds plea bargaining, and plea bargaining feeds mass incarceration. They're symbiotic, they work together, they rely on each other. The broader system of mass incarceration fuels the plea bargaining process, because plea bargaining is a process in which rights are not honored. People's experiences and choices and needs are not honored. And they are instead told to make terrible choices under terrible conditions that often result in lengthy prison sentences, onerous conditions, high levels of debt, and social control for years to come, regardless of whether they got a so-called deal or not.
The main reason that justice system actors, judges, prosecutors, and defenders say that they use plea bargaining instead of giving people a full constitutional trial is because of efficiency. They say if they had to give everyone a trial, the system would fall apart. We have privileged this form of efficiency over every other value in the criminal justice system, over accuracy, over reliability, over humanity, over proportionality, and over constitutionality.
Now, what we have is a system where around 98% of cases that are initiated for prosecution are resolved by guilty plea. We have a system of pleas, not a system of trials. People are left with very few choices, if any, and they generally take the least harmful choice available to them, and that's often a guilty plea. So we have the system for a number of reasons, again, none of which are accidental. Some of them go back to the origins of mass incarceration, how we got here, and the social forces that underlie it, right? White supremacy and racism, economic inequality, a desire for social control by those in power. These are some of the forces that contribute directly to the system of plea bargaining that we have. But also the rate at which we have relied on policing and prosecution to navigate social problems, to navigate social inequality, which, by the way, we have created. The rate at which we rely on law enforcement and the criminal legal system to address those problems directly results in the numbers of people being prosecuted that our system cannot handle. There's no reason that the evidence gathering that police do has to be so coercive. We could also make it a priority to fund public defenders.
There is no way that we would be able to administer and adjudicate this number of criminal cases if we had to give everyone a full constitutional trial. The only way we can lock up this many people is to do it via plea bargain. The decision that's being made with mass plea bargaining and mass incarceration in the United States is to choose conviction over every other value in the criminal justice system. Choosing plea bargaining instead of trials means that prosecutors, police, judges don't have to make tough decisions about who it is we want to impose punishment on in this country. What is the proper use of the criminal legal system? More and more social ills can be shoveled in this sort of endlessly elastic capacity that the criminal legal system has, as long as they get rid of all of the procedural rights and all of the values that are supposed to be expressed.
Sort of the central premise of guilt and innocence, of guilt and lack of guilt in our criminal legal system is entirely erased by the plea bargaining process.
Everybody knows that the criminal legal system in the United States needs to shrink massively. There are way too many people entering into the criminal legal system, way too many convictions, way too much surveillance. In some ways, the problem is quite simple. There's just too many people in the system. And it wouldn't be this way if trials were being carried out the way that they're imagined in the Constitution. Fair Trials believes in a system where defendants' rights need to be respected, where police behavior is scrutinized by the court, where the court makes sure that there's sufficient evidence to convict a person before they impose a conviction upon them, and where the public has the opportunity to see and understand what's going on in our halls of justice. These are the fundamental values in the human rights framework and in every criminal legal system around the world. And that's not what's operating in today's plea bargaining system in the United States.
Okay, thank you all for watching that. That's just to show you what it can look like at its worst in the US system. And I know, again, that that's not what we're looking at currently in Brazil. In fact, the last time I was in Brazil in 2019, I spoke before the Senate and the Chamber of Deputies about the dangers, these kinds of dangers of US-style plea bargaining, which at the time was being considered as part of the anti-crime bill that was supported by then Justice Minister Sergio Moro. And it was very wise and fortunate that your legislatures struck that provision from that bill that would have adopted the kind of plea bargaining that is described in that video, US style plea bargaining, with very few safeguards that, in my estimation, would have been very dangerous indeed to introduce into the Brazilian legal system. The new form of alternative to trial that you have now, the ANPP, the non-prosecution agreement, is a very different animal than what was proposed back in 2019 as part of the anti-crime bill. In fact, I would classify it as something closer to a form of diversion than true plea bargaining as we understand it in the US. Because if correctly implemented, it does not result in criminal conviction. This is a huge difference that's really important, and it's great news. The ANPP mechanism in Brazilian criminal procedure could potentially remove a significant proportion of low-level cases out of the prison and court systems, achieving decongestion in detention facilities, freeing up resources from more serious cases, and sparing the stigma of conviction on communities that suffer already from over-policing and discrimination. In this way, it can be a really important model for other global jurisdictions. But there's a number of uncertainties about specific key elements of how it's being implemented that leave it potentially open, this mechanism, for abuse and unintended consequences. One of the biggest concerns that Fair Trials has about the ANPP is its impact on procedural justice and torture prevention. You all have worked so hard in Brazil to implement custody hearings, and they're really at the forefront of criminal procedural protection in the world. And we talk about them everywhere. Share your experience with the world. It's such a victory for human rights proceedings that the world is learning from. To the extent that the ANPP agreement is occurring very early in the criminal process, perhaps even simultaneous to the custody hearing, we do have concerns that police misconduct and torture that may have occurred during investigation or arrests or interrogation may be overshadowed or hidden by the application of the ANPP. For example, it happens in the US at times that cases that are marred by police misconduct, in these cases, the defendant will be offered a very lenient plea offer in order to ensure that the case does not go to trial, that the judge doesn't see the details of the case, and that no accountability is realized. There's no cross-examination of the police officer, no disclosure of evidence, and questions about how the investigation and arrest played out cannot be raised in court. So it's critically important that the ANPP does not become a means by which police misconduct is swept under the rug, or which undermines the critical importance of the custody hearing and due process. There's also always the concern of innocence. The ANPP does require a confession for people to benefit from it. And that means that innocent people are going to be coerced into confessing in exchange for not being prosecuted. There's something sort of paradoxical in the fact that a person would have to submit to prosecution in order to protest that prosecution, and potentially stay in pretrial detention, depending on the case. So for this reason, I think it makes sense to look not only at plea bargaining systems per se to understand how the ANPP might be playing out, but also as systems of diversion, penal orders, community service, and fines as punishment, all of which are well known in Europe and in the United States. And I know that there's other speakers and other panels who are addressing some of these issues, but I just want to touch on a few of them to illustrate the ways that even tools like the ANPP, like diversion and probation and fines that are designed to decarcerate and decriminalize, can have a paradoxical effect and actually drive incarceration if they're not carefully managed. Now, I don't want to assert too much knowledge about how the ANPP operates because I'm not an expert on Brazilian law, but it seems to potentially create a form of court supervision for an unknown period of time. We have similar laws in the US that we call first-time offender laws. In these cases, low-level cases, for people being prosecuted for the first time, they can be given the option of, say, staying out of trouble for 6 months or a year, attending drug treatment, staying employed, or going to school. And if they comply with all these conditions, the case goes away and they don't get a conviction. And this is good, you know. I don't want to sound like I'm coming out against diversion or probation per se, But the devil is in the details, and the details involve more prosecutorial discretion, more subjectivity, less transparency, and less judicial oversight. Because the place that we're in now in the US, yes, we have 2.2, 2.3, maybe million people incarcerated in the United States, but we have more than twice as many, 4.5 million people under court supervision, their behavior being surveilled by courts as part of a criminal procedure, but they're not incarcerated. And 45% of people currently incarcerated in the states of the United States are there because they have violated a condition of their parole or probation. They violated a condition of supervision and are being incarcerated on that basis. So it's actually a gigantic driver of incarceration, even though these systems are put in place to keep people out of prison. They cycle them back in. And in many cases, they're put in prison not for the primary criminal conduct of which they were accused, but for technical violations of the conditions of their release, like not attending a meeting, testing positive on a drug test, or not paying a fine. So you can see how this sort of pattern might read over potentially in the AMPP context. It's unclear to me from the law as written what kind of conditions people are being subjected to, how these are enforced, and for how long. In the US context, we've seen how court supervision can keep people within the control of courts and prosecutors for far longer than they might have served with a sentence in prison. There's also much to be wary of in the way of monetary sanctions, which are explicitly imagined in the law providing for the AMPP, including both restitution to victims and fines per se. I don't have time to get too deeply into this issue, and I know that you've heard from others about the problems around fines and fees as sanctions for criminality, but it's not only the USA that has recognized the ways in which monetary sanctions in criminal proceedings can drive incarceration, even though they're supposed to be an alternative to incarceration. In Germany, for example, which heavily relies on fines as punishment and which has a system to make those fines proportional to a person's income, still about 50% of jail admissions each year are for non-payment of those fines. So even though it's not supposed to be a system that creates incarceration, it does, because people aren't able to pay their fines, because they're under supervision. Jail is always there as an option. So all of this is to say that global experience has shown us that even systems that are created in order to reduce incarceration or criminalization can over time come to drive these very systems through the creation of secondary surveillance systems that lack the due process guarantees of trial. Like, I don't mean to be a doomsayer. I'm very encouraged by the pivot the Brazilian legislature has made from copying US-style plea bargaining a few years ago to focusing on targeted decarceration methods through the AMPP. I think it's a wonderful thing. I'm very excited to see what the impact of this new procedure has on rates of incarceration and the life paths of people who've been arrested. But we must watch its implementation carefully and draw lessons from parallel systems around the world to ensure that it does not become yet another trap of debt and incarceration for people who have the bad fortune to be in contact with the criminal legal system. It should also not preclude other more radical efforts to truly decriminalize low-level offenses and to seek solutions to social problems that do not rely on police and punishment. Nor must it be allowed to undermine all of this country's recent progress at improving the rule of law by subjecting police behavior to the scrutiny of judicial review in custody hearings. I've just given a lot of opinions and information, and I'm really happy to answer questions and to be in further conversation with you all about how the AMPP is looking and what you all can do to ensure that it's being implemented fairly. Thank you.